Hi, Cohens here again doing another case study, and this will help give you a perspective on what the law really is and understand it. And this case comes from a time virtually at the founding of the Constitution when people were familiar with the original intent. And for me, it's the best decision the court's ever made almost 200 years later, called Cohens. That's with the plural, Cohens versus Virginia, 19 U.S. 264. And this was a big deal case because at the time, this is the first case that they had accepted from a state court to review a quote unquote criminal conviction. It was a very big deal at the time. And there were two sides to this, but the court, through Chief Justice John Marshall, by the way, that infallible icon of Harvard and Yale, who was never wrong, was he? Well, he certainly got it right in Cohen's. We could only wish they'd be obeying this stuff today. By the way, what I'm going to read mostly here is called dicta in law. In other words, the court didn't decide any of these issues per se, but they relied on them in taking the case and making the decision that they made. And you're going to read they're all very powerful what they said here. You wouldn't believe this is the Supreme Court saying it, especially not now. That said, first quote, by weighing arguments drawn from the nature of government and from the general spirit of an instrument, and urged for the purpose of narrowing the construction which the words of the instrument seem to require, that's the Constitution, it is proper to place in the opposite scale those principles drawn for the same sources, which go to sustain the words to their full operation and natural import. One of these, which has been pressed with great force by counsel for the plaintiffs in error, is that the judicial power of every well-constructed constitutional government must be coextensive with the legislative and must be capable of deciding every judicial question which comes before the Constitution and laws of the United States and is presented to us. And I say in a short annotation exactly the argument that I make and consistent with the original intent of the framers. Nowadays, all these bastards think they have is the appellate jurisdiction in which they have unfettered discretion to deny your case from being heard. And that's bad because that's the only court now that exists, the judicial court, in which you can be heard. I have a good friend that went through the entire process, did it their way, did it with their forms, did it with all of their requirements, and we got it there. The case was unopposed in May, and we thought they were going to hear this case and do a per curiam 2-paragraph reversal at the beginning of this last term in the Supreme Court. They issued a summary denial without even saying why they did it. So we can't reach them on the appellate side, despite what I just read you from Cohens v. Virginia. They can't be reached. If my friend couldn't reach them there, there's no way we can get there. And if we do, and we challenge the 14th Amendment, then Congress will do what it did 150 years ago in the case of William S. McCardle, 7 Wall 506, 1867, when they challenged the Reconstruction Act of 1867. The justices heard the case, decided the case, ruled that that Reconstruction Act was a bill of attainder, ruled 5-3. They never got to announce the opinion because Congress passed an emergency law, and it must have been one hell of an emergency, taking jurisdiction away from the court, and they didn't have the backbone and the integrity to announce the decision anyway, which would have changed the course of American history. Among other things, that immediately defeats the ratification of the 14th War Amendment. They didn't do it. So we can't get there on the appellate side. We have to go on the original side, and you acquire my documents. By the way, send me an email about that at youwinincourt@gmail.com. I'll send you info on acquiring my constitutional defense document packets and some other things. And you can learn for yourself. I mean, I do not make any of this stuff up. 90% of it I get from the U.S. Supreme Court. The rest of it comes from very highly recommended and recognized authorities in the Constitution. I don't make this stuff up. And here, that's what I'm reading you now. So returning to Cohen's, if any proposition may be considered as a political action, this we think must be so considered. In reasoning upon it as an abstract question, there would probably exist no contrary of opinion respecting it. Every argument proving the necessity of the department proves the propriety of giving this extent to it. This is the jurisdiction of the court to review every legislative act. If they can get away with enacting laws, which they're doing now, that can't be reviewed, where does our protections go with bills of attainder, ex post facto laws? I mean, so much that goes into this, and that's what they're saying here. We do not mean to say that jurisdiction of the courts of the Union should be construed to be coextensive with the legislative merely because it is fit that it should be so. But we mean to say that this fitness furnishes an argument in construing the Constitution which ought never to be overlooked, and which is most especially entitled to consideration when we are inquiring whether the words of the instrument which purport to establish this principle should be contracted for the purpose of destroying it, which is exactly what the bastards are doing today. Yeah, goes on. It has been generally held that state courts have a concurrent jurisdiction with federal courts. Are you listening, Tony Cantil Sequoia at the California Supreme Court? Damn. In cases in which the judicial power is extended, unless the jurisdiction of the federal courts be rendered exclusive by the words of the third article. If the words to all cases give exclusive jurisdiction in cases affecting foreign minister, they may give exclusive jurisdiction if such be the will of Congress in cases arising under the Constitution, laws, and treaties of the United States. This one at present is not true. It was true at the time. But given what you'll learn in my materials when you get them about the ratio of representation and quorum to do business, Congress hasn't passed any ballot laws since arguably the 1890s, and maybe before that. And guess what? That takes care of the Federal Reserve Act, don't it? Ain't out of there. Goes on. And this is dicta, I get it, but listen to this. The case of a state which pays off its own debts with paper money, frauds, Federal Reserve notes, no more resembles this than those to which we have already discussed. The courts have no jurisdiction over the contract. They cannot enforce it nor judge of its violation. Let it be that the act of discharging the debt is a mere nullity, and it's still due. But suppose the state to institute proceedings against an individual, you or I, which depended upon the validity of an act admitting bills of credit. Suppose the state to prosecute one of its citizens for refusing paper money, who should plead the Constitution and bar of such prosecution. If his plea should be overruled and judgment rendered against him, his case would resemble this, and unless the jurisdiction of this court might be applied to exercise over it, the Constitution would be violated, and the injured party be unable to bring his case before the tribunal which the people of the United States have assigned to all such cases. That's where we are today. We can't get there, and yet you can read 200 years ago we had every right to do it, and we do now. By their own words, they're saying this. And Cohens, to those of you that do legal research, look in your Shepard citations. This case has not been reversed, modified, nothing. This is all still there. Goes on. This is the best quote of the whole thing as far as I'm concerned. This is talking about what the framers had in mind. The Constitution gave to every person having a claim upon a state a right to present his case to the court of the nation. However unimportant his claim might be, however little the community might be interested in its outcome, the framers of our Constitution thought it necessary in the interest of justice to create a tribunal as superior to influence as possible in which that claim might be decided. Why can't we get there now? This can't be any plainer than this. And yet we can't do it. Goes on. It's most true that this court will not take jurisdiction if it should not, but it is equally true that it must take jurisdiction when it should. The judiciary cannot, as the legislature may, avoid a measure because it approaches the confines of the Constitution. We cannot pass it by because it is doubtful. With whatever doubts, with whatever difficulties the case may be attended, we must decide it if it be brought before us. We have no more right to decline the exercise of jurisdiction which is given than to usurp that which is not given. The one or the other would be treason to the Constitution. That's where I get this from. This is the court saying this. And they do this, especially in these damn traffic courts, every day. In every state court, you got treason. Because they haven't been taught this in law school, or they choose not to understand it. That's even worse in my view. That's strict liability treason. And that's 2,000 volts. And anybody that catches doing that, I'd love to be the one to be able to pull the switch. That's how bad this stuff is. This is Cohens v. Virginia, the best case they ever decided about this. And like I say, send me an email. I'll get you a copy of what I just read here. And the whole Cohens case. By the way, a point about Cohens. Earlier cases in this era particularly include in the official records, the U.S. Supreme Court reports. Not the lawyer's edition, not the Supreme Court reporter. I don't know how the hell anybody would want to use that. But they include arguments of attorneys on both sides of the issue. They are extensive in this case. And just like I said earlier, when I read decisions by the 9-0 farts, I read the majority, I read the dissent, I read the footnotes, and I will at least scan, if not read, everything in the arguments on both sides of counsel in cases of this vintage. Because now you get both sides of the argument, and we're going to know what we should be arguing and what the government is likely to put up against us and how to deal with it. That does take a little time and effort, but as Jefferson, I believe, once said, eternal vigilance is the price of liberty. I've been at it going into my 5th decade, 13 and a half years all in, and it's going to take you a little time and effort too. You're not going to get it right away. Don't feel bad. I was a slow learner myself. It took me a while. But when you have that aha moment like I recently had with the council issue, that's going to beat every case we have because they have nowhere to go with that. And you understand issues like this, that's what's going to shut them down. And you get cases dismissed, and in my cases to the point now where they very seldom file charges against me out here because they know where I'm going. They did file that jaywalking case last year, which is a bit of a surprise, and we'll talk about that at another time. They did file that. But generally, with traffic court, they're not going to do it. The commissioner gets the hell out of the way when I show up there. They don't want to deal with me because they know they can't. And if you get good enough at it, and you can do that with a little time and effort, and also what you can do that's important is teach your kids things they're not going to get at any point in time in 12 years of public education, and maybe not in 4 to 6 years of law school either. They don't want you to know this. Only the elite classes at Harvard and Yale and Berkeley, and very few of them, because they're going to be representing corporate government institutions in the New York banksters, and they may run into arguments like this and at least have to have some comprehension in order to know the best way to get their judge buddies from the State Bar Association to dismiss our cases. If we do our job properly, we can beat them. And I'm naive enough to still believe we can do that. And this Oakland case will go a long way to proving that one way or the other. So that said, you get a case like this one, this is gold. So send me that email, unincourt@gmail.com. Like my videos, tell your friends, and subscribe if you haven't already, and we'll go from there. Thank you.